our next caller is Carol, who's holding for us from McIntosh, Georgia. I thought it was Macon, but McIntosh, Georgia. Carol, are you still holding for us?
I am.
Good. What is your question for us tonight, ma'am?
My question is, I have some property that I want to leave to my 19-year-old and 13-year-old granddaughter. Now, how do I do that without going through the government and trust and all of that?
Well, that is a little bit of a tricky question when you're talking about leaving property to minors, specifically real property. So the best way to do that is going to be probably through a will to set up a trust. And I know that sounds really complex, but in this case we're talking about a testamentary trust that only goes into effect when you pass away, and then it puts parameters on what you want to happen to that property. So if you want it to benefit those younger grandchildren, you could state an age at which they could own it outright, but before they reach that age you could put a person in charge of it, that's called a trustee, who could help them manage it to make sure that they're able to preserve it.
Now, if they were both over the age of 18, there'd be a way you could put them on the deed, right?
Sure, absolutely. So if we're talking about everyone is of the age of majority, so a legal adult, then we can leave them the real estate. There are several options to do that with deeds. If you want to continue to own an interest in the property, you would do maybe a life estate deed where I reserve the right to continue living there for my lifetime, and then upon me passing away, it goes directly to the beneficiaries. If I don't want to own the property anymore at all, I could just go ahead and deed it outright to those individuals, but it's really tricky when you do that because it has implications for gifting and taxes that might be related to that. But what I see more in my practice is maybe grandparents or parents want to leave property to children or grandchildren, and they go ahead and deed it to them, and then unfortunately they need to go into a nursing home within a few years of having done that. And then we're running into potential penalties, not being able to qualify for benefits because they've made a gift like that. So gifting with a deed can be a great option, but it's not for everyone.
So like a right of survivorship, is that just for a spouse? You couldn't have that for
You could definitely have it. I have seen it in some cases with siblings. But again, another tricky thing that can come up is, you know, let's say you and I own it with rights of survivorship. I'm younger than you, and I'm counting on outliving you, and then you pass away first. I own it all. So I don't have to give your family, your child, any interest in the property if I survived you, so to speak. So survivorship deeds can be great for married couples, certainly, but not always working well in the estate planning when we're trying to leave property to several siblings. It can sometimes backfire.
Okay.
Like you said, it can be really tricky. There's a lot of little...
There's always, you know, but if, what if this, and what if that, and that's sort of what I think about all day long. All those what if scenarios.
Well, we turn to the experts.
And we were talking about on the break, you know, our firm, of course, we don't do any of that. We do personal injury almost exclusively, but these issues come up, and I was just saying, a personal injury claim is a claim to money, which is an asset like anything else, really. And so oftentimes we'll have the person will pass away before they can settle their claim, and then you got to get an estate set up. Or sometimes the person that is at fault passes away, and you got to have an estate set up. Not so much to go after their estate, but just there's got to be somebody there. You can't sue a dead person.
You have to have a legal representative of the estate either way. And so we do that often. I think get referrals pretty regularly from personal injuries attorneys, whatever side we're talking about, because we have to open up an estate so that we have a legal representative to move forward with that claim or to move forward defending the claim.
Right.